Our legal all-stars are back. Mike Davis, founder and president of the Article 3 Project, and Dave Ehrenberg, state attorney for Palm Beach County, Florida, where Mar-a-Lago is located. Mike, Dave, thank you for being here with us. Breaking news, Margot Cleveland of The Federalist just tweeted out the following. She's apparently been speaking with Ashley Merchant, lawyer for defendant Roman. Ashley Merchant confirmed to me, quote, "Yes, I spoke directly on a number of occasions with Terrence Bradley. He reviewed my pleadings for accuracy before I filed them. He unequivocally told me the personal and romantic relationship began prior to Nathan Wade receiving the contract as a special prosecutor on this case. This would explain why they tried so very hard, the state did, Mike, on Friday, to demolish this guy, even though at least on Friday, he said almost nothing. What do you make of it?
Well, now you have two witnesses. You have Fani Willis's friend / assistant testifying their relationship started. Fani Willis and Nathan Wade's personal relationship started back in 2019, long before she hired him to be her special prosecutor, long before she admitted to the court. So you have evidence there that Fani Willis and Nathan Wade committed perjury in two different courts, one in Nathan Wade's divorce court and one in this criminal court on the Trump prosecution. And then you have Nathan Wade's attorney / friends also corroborating this. So you have two witnesses, two friends of Fani Willis and Nathan Wade saying that Fani Willis and Nathan Wade's, I got the cart before the horse, Fani Willis and Nathan Wade's personal relationship began long before they testified.
That's a serious problem, Dave. And this judge in camera, in his courtroom, in his chambers, is going to hear all of that. Not all of it played out in front of the public, but as he figures out what's privileged and what's not, he's going to hear this. Ashley Merchant, I'm sure, has already represented and will continue to represent exactly to him what she just represented to Margot Cleveland. And I don't know whether he lets it in or prohibits it. He's got real questions about the wide sweeping assertion of privilege by this guy. They were obviously friends and colleagues long before he got retained as a divorce lawyer. But he's going to hear it. And he's going to, I think, accept Ashley Merchant's representation as an officer of the court, that this was told to her by Terrence Bradley. And he's actually got a confirming text from Terrence Bradley that we heard about, may or may not be admissible, that says it in writing. So he doesn't even have to accept only Ashley Merchant's word. There's no question that in the judge's mind, this is going to weigh more toward favoring the credibility of Robin Yearty and not so much Fani and Nathan. Am I wrong?
Yeah, it's a problem, Megyn. There are some tricky issues here. This would be a good thing for a law school class to delve into, because we're dealing with attorney-client privilege, which is held by the client, and the client is the one who would waive it. So if you're talking about the attorney waiving it, that attorney can get in trouble with the bar. That's one of the issues here, because the client, Wade, has not waived it. His lawyer, Bradley, looks like he may have waived it. And then you have an issue of, who did he waive it to? The other lawyer, Merchant, who was apparently informed, well, is she going to take the stand? She can't. She's the lawyer in the case. So this is really tricky, and it's going to all be in the hands of Judge McAfee here to determine what gets in. And because it is very relevant, although I disagree with all these other pundits who say, well, it's only about whether a conflict existed. No, because both Fani Willis and Nathan Wade both represented to the court that they didn't have an affair or didn't have a relationship, until after he started, then this is all relevant. And if they can show that these two are lying, then I think it is game over.
It's game over. I agree. Thank you for your honesty, because I couldn't agree more. Before they took the stand and before we had Nathan Wade's interrogatory or his affidavit swearing that the affair didn't begin until 2022, it was more abstract. But now you have representations under oath, his in writing and on the stand, and hers on the stand. All of it's under oath, Fani and Nathan, saying it didn't begin until 2022. And if this judge finds that those are lies, then they perjured themselves. And that's a problem for a civilian, and it's an extra problem for an officer of the court who has an ethical obligation to stop perjury when they know it's happening, never mind not to commit it themselves, Mike. So I agree with Dave. I think we're all in agreement that if the judge favors the testimony of Yurti and it considers this testimonial of Terrence Bradley in whatever form, they're both getting booted off of this case. It doesn't require that to boot them, but they will. What do you make, Mike, of the decision by the state to go after him, hammer and tong, on Friday, even though on the stand, he did no damage to them? Nothing actually got out because he just kept saying AC privilege, but they went after him as though, he had just been the critical witness against them and had said the things that we just heard in the Margot Cleveland text.
What's bizarre about this whole case, this whole disposition of this case, is you have these Fulton County district attorney lawyers who are supposed to be working for Fulton County, and they've turned into, it seems, personal attorneys for the politician / DA Fani Willis, along with her boyfriend Nathan Wade. And so you have to wonder, who's their client here? Is it the office, Fulton County DA's office, the people of Fulton County, or is it this politician and her boyfriend who are running this office? And that, to me, has been a head scratcher this whole time. Is who's their client here?
That's an interesting point. Let me ask you this, Dave. I don't want to get too deep into the legal ethics, but I do think you're right. This would be a good case for a law school to take a hard look at. And one of the reasons is, as I discussed with Phil, when you're a lawyer, you have an obligation to maintain attorney-client privilege, like Terrence Bradley would if he only learned about the affair through Nathan seeking legal advice. But you have a separate independent duty not to commit a fraud upon the court. And the law, the ethical obligations make pretty clear that when those two things conflict, it's your obligation to the court that trumps everything. So if your client comes to you and says, I'm going to take the stand and I'm going to say I didn't murder the person, and the client's already confessed he did murder the person, you have an ethical obligation not to suborn perjury as his lawyer. The ethical obligations, I just looked them up this morning in Georgia, say, first, you try to dissuade the client from doing it. And second, if that doesn't work, you should withdraw from the representation. And if necessary, you are supposed to raise it with the court. Like if the client goes ahead and does it anyway, you have an obligation to the court. And that's kind of the situation Terrence Bradley may be in, where he may know, let's give him the benefit of the doubt and say he knows it through AC privilege, that the affair began before 2022, and that these two people just took the stand and swore under oath the contrary. I think there's a good argument that his obligations to this court as an officer of it trump AC privilege and require him to disclose the truth. What say you?
I think when it comes to the divorce case, you can't suborn perjury. That's a trickier one because he may have had to, if that case is ongoing, correct things because you can't, as you say, you can't commit a fraud upon the court. In this case, the case we're talking about, he's not the lawyer. He's a witness. And I'm not so sure, as your last guest, who was really good, he said that it's not the responsibility of the lawyer to start correcting the record, especially when that lawyer is the witness and not the lawyer. So I think.
Okay, but wait, let me ask you a question on that. Let me ask you a question about it, because I know this is tricky stuff. We're all kind of in weird waters now because this doesn't happen very often. But why would the law require a lawyer in the course of representation, when the AC privilege and the relationship is at its peak? Why would the law and the ethics require a lawyer to betray his client there and all the way through the conclusion of that case, including pendency of appeals and so on, and not later, not a separate proceeding where the bond is, if anything, lesser and the reliance is lesser? And now it's like the obligation of the court is still there. I just feel like the interest in maintaining the attorney-client privilege only wane. They don't increase post-representation.
Well, you can't put on testimony that you know is false. That's a problem. And that may have happened in the divorce case with the interrogatories, and that's something that is ongoing he may have to deal with. But in this case, it's just a different responsibility as a witness. There is the crime fraud exception, Megyn, and this is where it gets kind of tricky The crime fraud exception says that pierces attorney-client privilege. And it applies, though, for future frauds. Does it apply when you're a witness and you see your client, in your view, lying on the stand currently to the judge? I'm not so sure. That's where it gets
I think
really
that's what
tricky.
Terrence Bradley needed to ask. I don't see crime fraud exception. I see your point. Crime fraud is when the lawyer and the client work together to commit a fraud upon the court at the time, and they try to shield their misdoings. I mean, frankly, it's kind of like a Michael Cohen situation where, he's representing Trump. They're allegedly working on something that they both know is illegal. And then they try to shield those communications where the lawyer's in on the alleged criminality by saying AC privilege. That doesn't work. But that's different than here. However, I do think what Terrence Bradley should have said to the court was, Judge, I have an obligation to maintain attorney-client privilege, and I have an obligation to you as an officer of the court. And what we need you to decide is when I have to choose between those two things, which one do I put above the other? That's really what this court has to decide. If not committing a fraud on the court is the most important thing, then you have to reveal the privileged information. If maintaining the privilege is the most important thing, and I'm satisfied you only learned this thing through AC privilege, not through your friendship, then that's a different ruling. So that's where we stand with Terrence Bradley. I think this judge is very smart, and I think he's going to make the right decision, Mike. I'm not sure either Fani or Nathan at this point is going to be solid in maintaining their bar card. I really think they could be in trouble. They could get disbarred if this court finds that they lied. And if he allows Terrence Bradley to actually testify and he says this relationship was started well before 2022, I really think both these people could be disbarred.
And much worse, they could go to prison for perjury and subornation of perjury and many other potential crimes. I would say this about attorney-client privilege. Not every interaction between an attorney and a client, as both you know, is covered by attorney-client privilege. Attorney-client privilege is to protect confidential communications between an attorney and a client where the attorney is providing legal advice to the client. So if you have Nathan Wade and his attorney who are friends in a situation where, in their role as friends, as you said, Megyn, he says that he started to date Fani back in 2019. That's not privileged. If you have this attorney observing Fani Willis and Nathan Wade in a personal relationship back in 2019, and this attorney is called to testify about his observations, that generally would not be privileged. And so there are ways you can figure out what this attorney knows about Fani Willis and Nathan Wade's relationship, I think, pretty easily without getting into attorney-client privilege.
Mm-hmm. I did think it was interesting, guys, didn't you, that we did not see the witness take the stand to say Robin Yurti's a liar? Remember we were talking about that when we chatted on Friday? That didn't happen, Dave. I did not see anybody take the stand to say, don't believe Robin Yurti.
They may have felt that she didn't hurt him enough, that the father who took the stand did well enough. And remember, Megyn, this was my prediction, that I still think, based on what we've seen in court, not what's in camera, which is behind the scenes in the judge's chambers, that this court, I think, still does not have enough clear-cut evidence that they lied. And so I think as of right now, he's going to dress them down in court. He's going to admonish them. But I still think that Fani Willis will be allowed to stay on the case.
Oh, my Lord. I mean, that would absolutely be stunning. And it would completely undermine this prosecution and the faith in it. I mean, the jury pool has seen this. They all, who's going to look at Fani Willis and Nathan Wade the same ever again? And in no way should Nathan Wade stay on this case. He's already a proven liar. I mean, there's just no question he lied in his divorce interrogatories. That guy's got to get bounced irrespective of anything else. But I disagree. Fani Willis is not long for the case either. All right, there's more to get to. Stand by. More with Mike and Dave next. Don't go away. Discover a holistic wellness solution with Bon Charge, a brand dedicated to optimizing every aspect of your life. Grounded in science and inspired by nature, their evidence-based products cover a broad spectrum of premium wellness items, from enhancing sleep and performance to boosting energy, accelerating recovery, and balancing hormones. Bon Charge offers a diverse range of benefits. Consider the infrared sauna blanket from Bon Charge that they say can burn extra calories and detoxify. This innovative blanket elevates your heart rate, simulating the effects of physical exercise. Bond Charge says sweating during the process helps eliminate heavy metals and toxins from your body. Setting it up takes less than a minute, and it rapidly heats up for a quick and convenient experience. For a limited time, save 15% by visiting bondcharge.com/MK and use the coupon code MK. That's Bond, B-O-N, Charge, CHARGE.com/MK, and use coupon code MK to save 15%. Guys, I want to do the Trump verdict, the $350 million verdict in a second, but it's a couple final points on Fani Willis. There is reporting out today by CNN that a Napa Valley employee, Stan Brody, is attesting to the fact that Fani Willis uses cash sometimes to pay for things. Willis used the money. She apparently took out a bunch of cash from her pocketbook when in Napa Valley, and he says she used the money to pay for 2 bottles of wine, each valued at roughly $150, and the $50 tasting, according to Stan Brody, who said he hosted Willis and a guest he later learned was Nathan Wade at Acumen Wines in early 2023. The media going with Mike, this proves she does use cash, and therefore we, I guess, are supposed to believe she was giving thousands in cash to Nathan Wade to reimburse her half for all these trips. What do you make of it?
This is such an unbelievable argument that Fani Willis is making. She even brought in her Black Panther father to come defend his Black Panther cub, Fani Willis, by saying that she keeps thousands of dollars, 6 months, up to 6 months worth of living expenses of cash in her house. Okay, she testified that she's done this essentially because her father told her to do this her whole life, but she hasn't explained where she came up with this cash. And as she's using this cash to supposedly pay for her half of these lavish trips to Belize and then, the Caribbean and Napa with her not so secret boyfriend / special prosecutor, she's paying $250 an hour out of Fulton County funds, $700,000, but she's not taking kickbacks, she says, because she's been paying with cash. Well, did she ever replenish this cash so she could follow her Black Panther father's advice and have 6 months worth of cash in her house? If she's spending the money, how did she replenish it? What's the evidence that she replenished it as the Fulton County DA? Are there any transactions in her bank accounts from her direct deposit?
For me, Dave, you tell me, first of all, this didn't come into evidence, so this is interesting to talk about for the three of us, but the judge doesn't get to consider this. He can't take judicial notice of out-of-court statements like this, which are hearsay. They didn't introduce this guy there. So it's kind of interesting, but not going to be relevant for the proceeding. But I also think it's really not this judge's problem that Fani Willis didn't get receipts for any of the cash or keep any records of it. It's her problem. She's the one who's been accused of improper conduct, of violating ethical rules, of taking essentially kickbacks from a vendor, and it's her obligation to prove it. Yes, she's got witness testimony. That's evidence. That's all she's got, and the absence of receipts should inure against her. It's not a positive. She's the one who should have kept the receipts. She shouldn't have done it in the first place, and she certainly should have kept receipts if she wanted to prove that she paid her fair share.
Yeah, I think that's the greatest weakness in her defense here, is that we are led to believe that she reimbursed roughly half of the expenses in cash and there are no records kept. Now, like for her case, she had her father, and if there are other witnesses, that could be helpful. Ultimately, it's up to the judge to say, no, I don't believe you, but there really is no hard evidence one way or the other, except for just a logical conclusion that, hey, come on, if you were getting these trips and you did reimburse, you would have some sort of receipt, some sort of Venmo or Cash App, and if not that, you'd write it down. But her defense is plausible, and she said that she was taught always to pay your way. A man is not a plan. She's had cash, and we can't disprove that. Mm-hmm.
But again, I don't think we have to. Robin Yurty is her biggest problem. And by the way, Mike, they did not prove disgruntled. I know we talked about this on Friday. Disgruntled, that means you're bitter, you're angry, and you've got like an axe to grind. That wasn't proven. They proved that she left the DA's office under circumstances that were not to her liking, that she was essentially forced out, resign, or you're going to be fired by Fani Willis. What does that prove? Okay, yes, I accept the way Dave put it on Friday, potential motive to get Fani, potential, motive to lie, but they didn't prove that. I mean, all they showed was that she was very good friends with Fani and that she left Fani's employ under circumstances that she didn't much like. Now, that doesn't mean, well, how do we get from that to this woman is willing to commit a felony and perjure herself on the stand to hurt Fani Willis?
Yeah, and remember, Fani Willis is not very considerate of her employees. Remember that Nathan Wade and Fani Willis submitted a court filing in this case where they attached Nathan Wade's false affidavit in his divorce case about his relationship with Fani Willis. And Nathan Wade and Fani Willis had 8 different lawyers in the Fulton County DA's office submit this court filing to the Fulton County Court, right, in response to co-defendant Mike Roman's motion to dismiss. Fani Willis and Nathan Wade knew that this court filing was false, and they still allowed 8 lawyers in the Fulton County DA's office to submit this court filing. So I don't think that Fani Willis and Nathan Wade care too much, about the fallout that their lies about their relationship may have with other people, because all they are doing here is looking out for themselves. They are clearly lying. They should be clearly disqualified. They should be prosecuted for perjury. And I think this case needs to be dismissed.
Well, they might be. All right, let's move on to the Trump civil fraud verdict. Judge Engoron ruled, as we expected he would, on Friday, the penalty nearly $355 million. My God, it's huge. He also ordered that they pay substantial interest, pushing the penalty for Trump up to $450 million. Trump's banned now for 3 years from serving in top roles at any of his New York companies or any New York company, including the Trump Organization. Sons Eric and Donald Trump Jr. must pay more than $4 million each. The judge wrote that the frauds found here leap off the page and shock the conscience. He wrote that Donald Trump rarely responded to the questions asked in this case. He frequently interjected long, irrelevant speeches on issues far beyond the scope of the trial. His refusal to answer the questions directly, or in some cases at all, severely compromised his credibility. The complete lack of contrition and remorse borders on pathological. He said this court must conclude that they'll engage in it again unless they are judicially restrained, in part given their lack of contrition. So I'll start with you as the Trump defender on this, Mike. I know you're against it. I know you think it's crazy, but what are the chances of it actually being reversed on appeal?
Well, this should be reversed on appeal for many different reasons. You had New York Attorney General Tish James campaign on the fact that she was going to get Trump, and she did that repeatedly, which is unethical. When she, during the first 5 weeks of this trial, as Congresswoman Elise Stefanik noted in a judicial ethics complaint against Tish James with the New York bar, Tish James made over 50 inappropriate, unethical comments during the first 5 weeks of the trial. So this case has been tainted by politics since before it started. You have this Manhattan judge, Arthur Engoron, who donated to Biden, donated to Democrats. He ruled that Trump committed fraud before the trial even began, before any witnesses came, before any other evidence. It was clearly a biased trial from the beginning. And then this judge, there's no evidence whatsoever of any victim. The banks got paid back in full, on time, as agreed, with interest. They still want to do business with Trump. They came in and testified to that. You can argue that New York law, you don't need a victim. Well, I would say this: if that's the case, then you have a problem with standing. If there's not a victim, you have a problem with constitutional standing. You also have a problem with an unconstitutionally punitive award here, damages award here, where you're awarding for almost $500 million, $500 million, when there's no victim, there's no damage to anyone, and they're going to try to award almost $500 million in damages. That is unconstitutionally punitive.
Dave, the New York State Court of Appeals, that's the highest court in New York, will probably eventually get this. It's more left-leaning. The U.S. Supreme Court could come after that, not left-leaning. So same question to you. I'm sure you don't object to the verdict, but do you think it will be reversed on appeal?
Unlikely, Megyn. It could get reduced somewhat, but it still will be a massive verdict. I'd like to start with the one area I agree with my friend Mike on, is that when you're a prosecutor, whether you're the state attorney or attorney general, you got to be really careful when you campaign and make comments like, I'm going to go after someone. That doesn't look good. Now, with that said, the facts are the facts. I mean, look, Trump here did it to himself by, for example, inflating his own apartment at Trump Tower, where he said it was over 30,000 feet when it was under 11,000 feet. I mean, that's not a rounding error. That's not just, a harmless puffery. That is a statistical fraud. And when you then show that he didn't have any remorse or any claim to mistake on all these other properties, and Engoron let him go. Engoron let him give part of the closing statement where he lit in Engoron, and Engoron did that to bend over backwards to make sure it would be upheld on appeal. And as to Mike said, you don't need to have a victim for it to be a fraud in New York. And even though you don't need a victim, look, you can make the argument that the banks were victims here. Even though they got repaid, they would have lent the money on more favorable terms if they'd been told the truth. And so, yes, I think this will be upheld on appeal, although because it was so huge, over around $450 million with interest, I think that it could be reduced somewhat, but it won't be overturned.
It's unbelievable. I have to say, there are questions now about selective prosecution in this case, because why Trump? Why, like, every real estate firm in New York has got to be shaking in its boots right now if they've done anything close to overstating the value of an asset in trying to get loans. This is what Kevin O'Leary, he was just on our show, Mr. Wonderful from Shark Tank, was saying to the New York Post. He said, you might as well find guilty every real estate developer on earth. He said, I want this reviewed and appealed and turned over because it's wrong for everyone that participates. Every developer, if this judgment sticks, must be jailed. They must be found guilty. They must be put out of business. You can't do this to one another. It's not about Trump. He says it's un-American. He said the shockwave sent through the real estate industry is insane. We're stunned. You have no idea. I mean, that's the thing. Is there a case to be made for selective prosecution? Is that something that can be raised on appeal at all? Like, why Trump? Why was he singled out? And did it have to do with Letitia James? I'll get him. I'll get him. I'll get him. I mean, we could play sound bites for the rest of the show of her saying that when she was campaigning, Mike.
Yeah, I mean, you could make that argument. The selective prosecution, as you both know, those are hard claims to make. But Tish James made the case pretty easy when she campaigned on the fact that she was going to get Trump repeatedly, when she's made over 50 comments during the first 5 weeks of the trial alone before we stopped counting, right? And so there's certainly evidence for a selective prosecution. I would say this about the fraud. Remember, with fraud, you have to have material misrepresentations of fact, and there has to be detrimental reliance. And the detrimental reliance is key. These banks do their own due diligence. So even if Dave is correct that Trump, misrepresented the size of his apartment, the banks do their own due diligence on this, and there's not detrimental reliance to the bank. So how the hell can there be fraud?
Yeah, that's what we heard. Even I heard that even on CNN and MSNBC asking that question on Friday, Dave. And, I heard a lot of lawyers say the banks were hurt, even if they don't admit it. So that's kind of where we are. There's no victim. You're a victim even if you don't know it, is kind of how the defenders of the verdict are taking this. The heart of this matter, the problem is caused by two things. This wacky New York law that allows it, even where there is no victim. And I think just the hatred of Trump. I just think he was singled out. There's no question they went after him because they were looking for a crime, not for, that this man maybe did. And honestly, Dave, how are we supposed to make sense of you didn't express remorse? He's denying that he did it. Does every defendant now need to say, I didn't do it, but if you find that I did, I'm really, really sorry, in order to avoid punitive damages? Like this is insane. Of course, same thing on E. Jean Carroll. The reason he talks about her so cavalierly is because his position is, I never did it. She's a lunatic. Both of these courts have something similar in that they seem to be punishing him for not admitting the accusations against him.
Well, it goes to damages, I think. It's not like the fact is, Judge Engoron said, you did this, you clearly inflated the values and you knew it, and you should have been. Here's the example. How do you triple the size of your apartment? That's not a valuation. That's a measuring. You just need a ruler for that. And yet, when it comes to this massive judgment, I think that's where the lack of remorse, the cockiness, the arrogance, I think that's where it came into play. One last thing about the damages here. Even though banks got repaid, other individuals would have been loaned that money on more favorable terms for the banks if Trump had not inflated his assets. And so that's where it comes into. So the banks say, yeah, we got repaid. Yeah, but there's an opportunity cost there. You would have made a lot more money somewhere else if you weren't lied to. And one last thing on that.
Talk about speculative damages. You have to prove damages in a court. You can't go that speculative. Sorry, keep going.
Well, right. Well, one last thing. Trump defended himself by saying, we told you that we were liars. We told you, don't trust us. And he called it a harmless clause. But the clause there was not really what he said it was. It didn't say, don't trust us, we're not telling the truth. That would have gotten him away with it. He could have been given a pass if that were the case. He had some vague clause that they were hiding behind. And I think that also struck the court as another instance of intentional fraud.
The problem as I see it here is, of course, Trump played fast and loose with these representations. That seems clear, as do virtually all realtors in New York. I mean, I know this one guy who's in real estate who said his father would be ashamed if he ever found out that the son had paid $1 in taxes, would be ashamed of him. Real estate moguls in New York have ways of manipulating their bank loans, their taxes, and so on that we mere mortals do not have and wouldn't know how to take advantage of even if we thought we could. And it doesn't feel fair. It doesn't feel right to those of us who are just like, salary employees and our taxes get sucked out and that's the end of that. But they're there, and people like Trump and others are taking advantage of it. It's just Trump's in the news because Trump's hated by half of the country and by half of the judges and so on. And so I think that Mr. Wonderful has a good point. You could do this to a lot of people, not just Trump, and it feels very persecuty to me, and I'm sure a lot of others. You guys are the best.